welcome to Talking DV, a podcast that focuses on domestic violence and practical guidance on how to leave a relationship where your husband, wife, boyfriend, girlfriend, or whoever might be harming you. My name is Dean Hinton. I'm a licensed attorney in the state of Tennessee. For almost a decade, I've handled cases involving people whose partners have been physically, emotionally, and financially abusive to them. By providing practical guidance to you, my guest and I will hopefully help you escape harmful relationships. With me today to talk domestic violence is Rebecca Toca, a former prosecutor in the state of New York who now works in the Nashville office of legal aid, while I work in the Gallatin office of legal aid. So we are both legal aid attorneys. Rebecca has extensive experience with orders of protection. And so today we're just going to dive right into orders of protection, what they are. And Rebecca, let's just start off by talking about what is an order of protection?
Just generally with orders of protection here in Tennessee, they're civil orders of protection. And I do think from the beginning, that's an important thing for folks to understand. This is a civil order. It has nothing to do with any related criminal cases. It's a civil court order. Up to 1 year is the typical order that we're talking about here. The person's ordered to stay away from you, not to contact you. There could be a lot of conditions under that, which I think we'll talk about more, because it can be a very helpful tool, especially if folks have children together or they were living together. Under an order of protection, you can also get certain relief, financial support, or possession of your residence, things like that, if you're granted the order of protection. Even custody of your children can be granted under the order, or temporary custody of your children can be granted under the order. So it's a very powerful order in terms of being arrested. Once it is ordered, once it's in place, the person who's been restricted from the contact or restricted under the order can be arrested without basically just a police report. You can report them to the police and they could be arrested for criminal contempt. So you do have that protection when you have the order.
Yeah, the beauty is, or the thing is, the boundary perhaps, is the automatic arrest. Otherwise, if the husband, wife, whatever, obviously they can stay in the same household, but if someone has an order of protection, has been ordered not to contact or communicate with this person, the boundary's been established and police know who to arrest because someone violated that order.
And I think one of the biggest reasons that this is primarily used for intimate partner violence is, while there are some exceptions to that for sexual assault and stalking, but for intimate partner violence, it's so useful because, yes, a lot of times these parties live together. If one does not have the financial situation to just go out and, get a hotel room or rent a place, if you file for an order of protection and you're granted the ex parte immediate order of protection, then that other person has to stay away and not come home. Even if their name is on the lease, even if they own the house, they can be told that they have to stay away until a hearing is held. And then if the order of protection is granted after the hearing, they could still have to stay away from that home, even if they own it. They own it, and there can be conditions put in that they still have to pay the mortgage or pay the rent, depending on the situations, of course. But so it's a very powerful order.
And we're talking about orders of protection in Tennessee, but I did a little research before today, and I saw in other states and other jurisdictions, which we do not practice in, but just for comparison purposes, the order of protection in those jurisdictions might be called victim protective order, a protective order, order against abuse, anti-harassment order. I think Washington has one of those. Civil protection order, emergency protective order, DVPO, domestic violence protective order. So depending on where someone hears this, they might call the order of protection something different in those jurisdictions. I just thought I might point that out, that again, we're talking about orders of protection here in Tennessee, but in other jurisdictions it might be called something else.
Nice about it is, of course, a person who's being, if a crime is being committed against you, you can always call the police and hopefully they'll be coming in and taking action and possibly issuing an arrest warrant, depending on what the person did. But what's nice about the order of protection is once you have that order of protection in place, it doesn't have to be a crime against you. It could be any contact. So once you have that order of protection, even if this person is love bombing you and sending you texts that say, I love you, I miss you, I'm sorry, that is a violation of the order, and now that is a criminal offense, and now they can be arrested for doing that automatically.
So if Becky has an order of protection against Dean, and Dean is nice and wants to knock on the door and say, hey, how you been? Here's some flowers. I still care about you. That, and again, there's an order of protection in place. I could be arrested immediately. Becky can go to the phone, pick up the phone, say, he's here. I have an order of protection. I will be arrested and hauled away to jail.
And it's just a great help in those domestic violence situations, just because if you're familiar with the cycle of abuse, when someone's trying to leave, it could be the most dangerous time in that relationship. And so when someone's trying to leave an abusive relationship, if they can get this order of protection, it just gives them that extra layer of this person can't even come here to try to apologize or make nice. And so it gives them that little extra support when they're trying to leave an abusive situation.
Yeah, and I thought it might be helpful to explain the difference between, in Tennessee, we have something called a restraining order, and then we have an order of protection. Those are two different things. So a restraining order is not an automatic arrest. If there's a restraining order, let's say in a divorce situation, if Dean has been ordered to stay away from Becky through a restraining order, if I come up with flowers and knock on the door and say, hey, how you been? Becky has to go back to court and hold me in contempt and ask the judge to put me in jail for going up to the door and knocking on it with flowers. So that's the difference. There's no automatic arrest. You can't call police with a restraining order, but obviously with order of protection, as we've already stated, you should be able to call police and come out and show the police what happened. So you just alluded to this a minute ago about being able to ask for things other than just a stay-away order, just an order of protection. In other words, no contact, no communication. Such as in Tennessee, you can ask for child support, alimony. You can ask, what's one of the other ones?
You can ask for one of the protected party to get to stay in the marital residence and have exclusive possession of the marital residence. Or in the alternative, if they're not staying in the marital residence, you can ask that the restrained party have to help pay for their new housing.
Yeah, suitable housing.
Suitable housing. You can ask for a lot of things in terms of support. So spousal support, child support, sometimes they'll call it family support. Usually under the order of protection, it won't be as formal as under a divorce. They might do a child support worksheet if the order of protection is granted, but sometimes they'll just seek to get basic information from both sides and try to keep the status quo. So if the restrained party was paying the mortgage, maybe order that person to continue to pay the mortgage or continue to pay certain utility bills. Everything from under orders of protection, you can continue to pay phone bills, continue to pay car insurance or car notes, monthly expenses of that nature, continue to pay things for the children. Whatever the status quo is in that relationship financially, you could try to keep that going under the order of protection, which is so helpful because if you get that order of protection, whether it be a full year or just 6 months, if it's ordered that this person's to continue paying certain things, pay certain support, then once you file for a divorce, that could be extended by operation of law in Tennessee, and you already have that support order in place when you start the divorce. Versus the alternative of going into a divorce without an order, then you have to file a motion for temporary support, come to court in a couple of weeks, and try to get that order in place, which by the time that happens, you're talking 3-4 weeks probably that you're actually getting that support. But if you have filed for an order of protection and requested those things, you will already have that, hopefully, under your order of protection. And sometimes they'll do it right there at the end of the order of protection hearing. I have even had judges here who will, if there's a lot of information that needs to sort of be identified, set a separate hearing just to discuss the support.
I like that idea. I like the idea of being able to do all these things in an order of protection, including, I didn't even know this was in the statute. I looked at it before I came in here today. The other person can be, the abuser can be ordered to attend counseling.
Yes.
I've never seen that. I've never even asked for it. And to set visitation schedule with children, among other things. There's a list of things that can happen. But here's the question. Should you ask for those things in order of protection? And here's why. It gives, in my opinion, in some instances, in many instances, it gives the judge pause why you're seeking the order of protection. I'll give you an example. In Macon County, Tennessee, this was not a client of mine. This is something I noticed on the docket, and I was in court when it happened. The person asking for an order of protection, the reasons they were asking for an order of protection would not be granted. There was no physical violence. There was no threats of physical harm. I think there might have been some name calling and stuff like that, and we can get into this in a minute, the reasons why an order of protection would be granted. But just on the face of the petition for the order of protection would not be granted, but the person wanted alimony and child support. And the judge said, go away and come back. But in the meantime, the judge said something to the effect like, this is just an alimony and child, you probably need to go file for divorce. And that person did not file for divorce. So what I'm trying to say is, in some instances, if you're starting to put in a petition what you're asking for, and it looks like you want some sort of financial support, I've heard orders of protection be called mini divorces, and people don't like it for that reason. People, I'm talking about in the legal community, other attorneys and so forth. All of which to say is, you can ask for these things, but be careful what you ask for, because it might tip the judge off that this case is something other than safety.
Well, I do agree that in your petition should focus on why you're asking for the order of protection, why you the abuse, and why you need protection. There are parts of the petition here in Tennessee that you fill out that are just checking the boxes, that you do check the box that say you either need, you're asking for possession of the marital home or certain support, but you don't have to get into details there. I don't ask for any of these things until the OP is granted. and sorry, if I say OP, I'm obviously talking about order of protection here in this context, since that's what our topic is today. But if it is granted, during the OP hearing, I'm not discussing the need for support or the financial situation unless it's somehow relevant to the case. This is at the end. Once it is granted, you can ask for these things under the statute. So once it is granted, that's at the point where I say, Your Honor, we are asking for child support or spousal support or whatever other things that we're asking for. You mentioned counseling. We have had batterers intervention programs ordered under the statute or under the order of protection, parenting classes, things of that nature. So you can ask for all of those things after it is granted. No, I would not really bring that up before it's granted, because otherwise it's really not relevant unless it's granted, because the judge you're in front of for the order of protection does not have the power to order these things unless the order of protection is granted. So that comes up at the end. You ask for them. Our judges don't seem to hold it against the client that they're asking for those things at the end. I mean, sometimes if they're asked for during the hearing, I would think that might give some judges pause, and so you would have to be careful about that. But at the end, I think it's a reasonable request, because if these two people were living together, especially, you are now taking two adult, typically household, and separating it into two, and having two estates now on the same income. And so it is going to be reasonable to ask for some financial request during that time. And they're temporary. This is just for however long the order of protection is in place. Maybe it will be extended for some later, but it's a temporary order.
So with that in mind, and I think you've said this already, so in preparation, whether you're an attorney or whether you're doing this yourself, you don't necessarily have to have that child support worksheet, or you're just going to say, based upon, where do you get the numbers?
If I know the parties that are married, live together, have kids together, I might have them in preparation for the hearing complete an income and expense worksheet, just so I have that ready, provide me with some, so I understand their income and expenses, and that way we have that ready going into the hearing, and then if we get to that point, we can talk about it then. What I find is sometimes the other party's not bringing that to court that day. So we're either going to have to go with what we know about the other party, if they have the kind of job that we know what their income is. Different parties come with different financial situations, but if we know the other person's income and my client can sort of speak to their financial situation, then sometimes that's enough to get something ordered under the OP. But that's what I'm talking about when I had one case where the order of protection was granted for a year. The parties owned a home. They had 2 children. So it was a bigger discussion of how are we going to pay this mortgage? How are we going to provide for these children at the end of the order of protection hearing? And the husband had brought nothing to court. And the wife really didn't know about their financial situation because he pretty much kept her in the dark. So that judge said, okay, let's set a separate support hearing in a week or 2 on his schedule. We came back and husband was ordered to bring his income and expense statement and proof of his income to that hearing, and proof of the mortgage balance, things of that nature, so that we could sit there and say, okay, for the next year, what's going to be the order here? And that was very helpful.
So that's what an order of protection is. It's an order really about safety, and the emphasis on safety, and some of these other issues come secondary. So if a person thinks that they need an order of protection, the first thing they're probably going to ask is, what do I do? Where do I go? Are you going to have to file, in Tennessee, you're going to have to file a petition for an order of protection, puts the court on notice and the other party that you want to be protected from that person. So where do you file? And I found some examples across the state of Tennessee. This isn't a complete list. It's to give people an example of where to go to file for an order of protection. For example, in Davidson County, Nashville, where you practice primarily, right?
Yes.
You would go to the Family Safety Center. It's 610 Murfreesboro Pike in Nashville. The zip is 37210, and it's open 24/7.
They are staffed 24/7 with advocates who will help petitioners, victims. They'll talk to them. They'll do some safety planning, and if the person wants to go forward with an order of protection, they can help them right there. Fill out the petition and submit it electronically to the judge who's on duty. At nighttime, it'll be a night court judge, and that will get reviewed, and they'll get an answer while they're there at the Family Safety Center. They don't even have to physically go downtown to go to the courthouse. Now, in the alternative, if they don't go to the Family Safety Center, I think they still have the option to go to the night court commissioner. I forget the exact title of the office, but they could go downtown to night court and do it there. They can hand fill out the petition and submit it there. But if they go to the Family Safety Center, they have this advocate who will help them, who will type it up for them, and electronically file it for them.
Yeah, my understanding at the Family Safety Center, survivors used to appear on video or something, but they don't even do that anymore.
I don't even think I think it's done over the phone. Something I'll also note is, honestly, those are the two ways to file for this civil order of protection. Really, there's no option. You hire an attorney later, and that attorney wants to maybe amend the petition and file that with the court, they can, but this is the best way for a victim to file that emergency order of protection because they get heard right away. The sheriff then, after it's filed, goes and serves the adverse party as soon as possible, and so that's the way that you do it here in Davidson County. And as you know, in some of the rural counties, it might be a little bit different. If there's a family safety center in your county, they certainly can direct you to how to do that here in Tennessee. And if there's not, you would go to probably your local courthouse and see what the options are.
Yeah, that's what I would recommend for rural counties, especially, is go to a courthouse. And somebody also said, well, just for information in general, is thrift stores. They generally know a lot, but they wouldn't be able to help you file for an order of protection, but they might have information about where to go to file. But I would go, if you're in a rural county, anywhere in Tennessee, or even outside of Tennessee, the first point of contact would probably be the courthouse. Clerks there usually know what you're asking for, and they probably even have forms for you.
And sometimes, just to be clear, I know that in some counties and other states, sometimes it's called the Family Justice Center. Here, our local one is the Family Safety Center, but I have heard that interchangeably, safety or justice. But
to give people other examples of where you could go to file for, like we're here in Sumner County, that's where we're broadcasting from. So you could go to the jail, the Sumner County Jail, which is at 117 West Smith Street in Gallatin 37066. You can apply with the magistrate there 24/7, 365 days a year. You can always go to apply for an order of protection. In Shelby County, you can go to the Crime Victim and Rape Crisis Center at 1060 Madison Avenue in Memphis, 38104. That's not 24/7. You would think Shelby County, Tennessee would have a place that's open 24/7 to get an order of protection. You could probably go downtown in Memphis to get an order of protection from one of their magistrates. I don't know that. I don't practice in Memphis. I got this information from attorneys in Memphis, but they didn't mention anything about going downtown. In Hamilton County, Tennessee, you go to 625 Georgia Avenue, which is the county courthouse, and ask for an order of protection. That's not open 24/7. In Rutherford County, you go to the Domestic Violence and Sexual Assault Center at 1423 Kensington Square Court in Murfreesboro, 37130. That's not 24/7. So it really depends county by county. The point of that whole exercise and telling you where to go is that in Sumner County, you can apply for an order of protection 24/7. In Davidson County, but not all counties are the same. And if there's an arrest, if there's a police officer that you're involved with because of domestic violence, the best thing to do is to ask that police officer where's the best place to get an order of protection and how quickly and whether they're open at night.
Right, and I will say, yes, police officers usually do know where to go for that. They're usually provided with that information, at least in the counties I cover. They'll offer folks to either go downtown or go to a family safety center. The other thing I'll mention about that is I do think clients sometimes, if it's late at night, they'll say, oh, I can't go do anything right now. Wait, one, make sure you're safe, whatever your decision that you're making in that moment is, in terms of if you're not going to go file that order of protection right away. But I will say, while it's not a requirement to file the order of protection right away, I do think that once you're in front of a judge later for a hearing, the sooner you can report something, the more strength there is to those allegations. Now, of course, there's so many reasons why people delay reporting or they delay filing for an order of protection. I'm just sharing that to say that if someone is thinking of this later and it's late at night and they're like, I can't go do this right now late at night, it's like, no, check, maybe you can. And if you can't do it that night for some reason because it's not 24/7, option in your area, just go as soon as you can the next day, and then try to make sure you're in a safe place that night, which might not be friends and family, because your abusive partner knows where the friends and family live. You might be staying somewhere they're not aware of, either shelter or a safe space that they don't know where you're going to be.
The place that you go to fill out an order of protection will have the forms for you to fill out. And when filling out an order of protection, a petition for an order of protection, that's what it's called here, a petition. It might be called something different if you're outside of Tennessee. Start with the most recent incident first. Whatever just happened, tell who, what, when, where, how. Just go through exactly what happened, whether a weapon was used, and whether it's strangulation and that sort of thing. Judges are going to be looking more for physical violence than name calling or put downs or emotional abuse. I see a lot of orders of protection where the person writes that they've been called foul things, which is bad. We all don't want our spouses to call other people bad names or put downs or maybe even threats. But punching holes in the wall, by the way, is not. It doesn't get much impact in my area. Judges seem to put up with punching holes in the wall.
Right.
But intentionally harming children, children, that's significant. Sexual violence, that's significant. Hurting animals, that's probably significant. But again, the judge is looking more for physical violence than they are with emotional, psychological abuse. That's what we would call it. There's other things, there's other bad things that happen in, unfortunately, relationships. You could put those down, especially if the abuser's hurting you, but the words are probably less impactful unless it's threats to kill you or harm you than it is physical violence.
Yes, I was going to say, so in whatever jurisdiction you're in, most of these forms are available online. I know in Tennessee you could go to the Administrative Office of the Court's website, I believe, to get a copy of the order of protection petition. Most of your local jurisdictions probably have that online. If you take a look at it, a lot of the time there's like fill in the blank sections where you're checking off things or filling them in. And then here in Tennessee, there's a narrative area. So it is a blank space, blank page to fill in a narrative. And if you have an advocate helping you, hopefully they'll help you sort of organize your thoughts and sort of lead you to put the most relevant information first, like Dean said, or the strongest incidents or the incidents you have the most evidence of, highlight those first in that narrative section. What I like to tell folks too is, like you said, obviously physical violence is going to be the first thing. Threats of physical violence, threats to kill, threats to harm are good to put in there if you have those, and if you have it, if you're able to prove them, if you have text messages, recordings, that certainly helps. If you have physical injuries, like describe those in there. If there's bruising, take photographs. Sort of when you're filling out this petition, remember that there's going to be a hearing later. So it's not just telling the court, hey, this happened. Hey, yes, your testimony is evidence, but do you have anything to corroborate that? If you have bruising, if you have scratches, if you have redness, take some photographs and keep those yourself so that in a safe place. If you're taking these photos on your phone, remember your spouse may have had access to your phone at some point, may have had access to some of your passwords. So email those photos to a safe person or to a secret email account so that you have some corroboration. A lot of times victims will say, oh, but the police took photos of me. And it's like, oh, it's not always that easy to get your local police to get copies of those photos they took. So take your own photos and just include that information into your petition. Like Dean said, while of course the insults and the emotional abuse somewhat relevant, that doesn't really need to be in the petition. What needs to be in the petition is what abuse that is listed under the statute that will give you a basis for that ex parte order of protection to be granted, and then you'll need to prove that at the hearing later if you want it to be granted for a longer period of time. Like you said, with the children, I would obviously intentionally harming the children would be relevant. If you want to keep your kids on the order of protection with you, just be ready that it is harder sometimes. If they are present during the abuse, you certainly want to include that in your petition, that they witnessed the abuse, but be aware that it sort of depends, very fact specific, like what kind of abuse was it? Was it physical abuse? Is the child old enough to understand what's going on? Was the child in the middle of it, or was the child in the other room watching TV? These are all the things that the judge is going to consider later. And like you said, if the child wasn't either intentionally harmed or witnessed something very traumatic, these kids may or may not, that's the basis to keep the kids on the order of protection. So just be aware of that. Another thing that was recently added to the statute is financial abuse, which admittedly that was recently added. I haven't had many cases where you can actually prove the financial abuse yet in court, but be aware that that's sort of a very difficult thing to prove, but it's not just someone who's very controlling with the finances. It really needs to be someone who is forcibly limiting your ability to earn money or completely keeping you away from the family resources. It's going to be hard to prove financial abuse if you don't have something like that. Someone who's just very controlling with money alone is not going to be enough to prove that. So just something with a newer area of law that I haven't really had a case yet that has come up that we could prove financial abuse.
I saw the statistic on one of the national websites, the national DV websites, and I can't cite to it specifically, but it said in 90-something% of the cases involving domestic violence, there's financial abuse. There's what we call financial isolation. Someone's cut off from money. But I agree that you're going to probably need a lot of information to the court for them to even consider granting one. I don't really see many of my judges granting an order of protection based strictly on financial abuse.
Correct. And I think that's exactly what you said. I see it a lot. I see it in a lot of the cases we have where the victim is restricted from the money, or the abuser has complete control. I guess what I'm saying is an order of protection hearing has to, by statute, this hearing is happening within 15 days after the abuser is served. The kinds of things that you need to prove financial abuse are probably going to take you longer than 15 days to get, especially if the husband is the one who controls all the finances. So bank account records, credit card records, different details like that are probably just going to be very hard to show within 15 days. Maybe it's something you can show in the divorce case once you've done full discovery and you have all these things that you've been able to subpoena and show the court, but just for an order of protection hearing, while it's very nice that that was added to the statute, it's just remember, this hearing has to happen within 15 days. And so sometimes that can be very hard. That kind of abuse can be very hard to make a case on in 15 days. Less than 15 days, usually, by the time an attorney is involved and is prepping for the hearing.
I would go maybe one step further and say that judges that I appear in front of and more familiar with would probably be asking, maybe internally, maybe not outwardly, but whatever, why is this being filed as an order of protection? This sounds like a divorce matter. And so it sounds like something that you're trying to, square pegs in round holes, or something that this isn't really being addressed in the right way. And you mentioned something just a minute ago about photos and how necessary it is to prove your case. As a matter of fact, I think that's very, very key to winning, if there is such a thing as winning an order of protection case. And that is, a couple of years ago, pre-pandemic, I was involved in an order of protection case in Wilson County, and the order of protection did not get granted because the client, the witness, the alleged domestic violence survivor, got on the stand and said, well, my husband injured me, and this is how he injured me. And she didn't have pictures of bruising, but she had a witness there that said, I saw the bruising. And the judge told her, everybody's taking photographs of everything these days, especially you young people. She was younger. Everybody's taking pictures of everything, and so I just don't buy it. You would have had a picture to bring to me, young lady, to show me, and so he dismissed order of protection. And so if you don't have pictures, do not rely on police. Do not rely on anyone else. Take your own. Take a lot of different pictures. I've had people bring me pictures that were terrible pictures. Right. And they were, I don't know why they took pictures the way, and I don't know why they thought a judge or anyone else would want to see this picture. It was really tiny or something like that. Take pictures from different angles and save them and put them somewhere safe and send them to a friend or something so they have them, so you can preserve this and make sure the judge sees these pictures of bruising, because it's very important to winning your case in court.
Right. And I just think of it as your main evidence at the hearing is going to be your testimony, and that is evidence, but anything you can get to corroborate your evidence is helpful. So photos the day of, sometimes bruises don't show up right away. Go ahead and take them a photo the next day, or a couple days later, to show how the bruising developed. That's fine, because you can testify about, okay, I took this one the day of, and then the next day it got darker. You can testify and explain the photos a little bit, give them context. So definitely try to get those if you can. It's very helpful. If there is a witness, I will say, if there was a witness to anything that happened, that witness is going to need to come to the hearing too. Sometimes there'll be a family member who maybe sees something, or a neighbor. When that is mentioned in the petition and then that person doesn't come to court, it's sort of like a missing witness. It's just like you're giving them doubt to hand up to the judge, right? Because why isn't that witness here? And you can't say, oh, I'll get an affidavit from that person, or they can't. Unfortunately, no, they have to come to court and testify if they did witness something. So if you're going to mention a witness, or if there were witnesses and they're an adult, or really if they're older than the age of 13 or older, they might need to come to court to testify. Children who saw things happen in your home, and that child is old enough to testify, while obviously you have to sort of debate whether you want to put your child through that. If they saw things happen, then you might need them, have them come to court and be ready to testify if you want to get this order of protection. So that's just something, obviously different fact-specific situation. But
as an older attorney told me a long time ago, you need a butt in a seat. You need a butt in a seat to testify, because, like I think you're sort of alluding to, some people think, well, I'll just testify to what they said, that's hearsay, or I'll get a letter from somebody, or whatever. You need someone to come testify on your behalf if it comes to that. That's how you're going to persuade a judge.
And I'll give a couple other tips on that topic. Just sometimes folks will tell me, I have the police reports. I'm going to bring the police reports to court. It's like, well, no, you actually cannot introduce police reports. That there's hearsay in a police report. So that's not going to work in a civil order of protection hearing. Now, for a criminal case, DA's office they have a system for where they notify the officers, and the officers will testify in court at a criminal case. In a civil case, yes, you can subpoena the officer, but it's just a little bit more complicated. And like I said, when you're working on a short time frame for an order of protection, it can be harder to get those officers in for a civil hearing. The other thing is medical records. If something happened where you went and sought treatment, urgent care, doctor, whoever, and if it says something in those medical records about why you sought treatment, you were strangled, you were assaulted, any of those things is listed in those medical records, that can be very helpful, because that can be introduced. But in order to introduce them properly in a hearing, they need to be certified medical records. And so sometimes clients might bring me their discharge paperwork or something they got, but it's not certified, and it can take a little time to get that certification. So So just if you're the victim and you did seek medical treatment and there might be statements in there that support what happened, or maybe your injuries are described in those medical records, that can all be helpful. But just you as a victim or the client, you can go request certified medical records. And if most medical providers' records offices know what that certification is, but it's basically a business records certification that these records were made close in time to the medical treatment and that they're complete and there's certain things that need to be listed there. And if that's signed by the custodian of those medical records, you can introduce that in court. So just saying that because, hey, if you're representing yourself and you did get medical treatment, you may not know that, but you could go get those certified records yourself and bring them to court and use them at your hearing. Your attorney can try to get those as well, but it's honestly harder for your attorney to get it. Your attorney has to get a release of information from you and then try to work with that medical provider to get it. Honestly,
or subpoena them. But
correct. It just takes longer.
Yeah.
So point being, the actual patient, the actual victim, if they go to the records of that hospital or that medical provider, they can usually get them a lot quicker.
If you're applying through a petition or whatever for an order of protection or testifying in court, I would refrain from saying that you are afraid of what this person might do. You want to put down in facts in a petition what they did. A lot of people go into court and they say, he called me the B word, he called me the W word, he peeled out in the driveway, he was really angry, he says he's going to be back later. I'm just afraid what he might do. That's not going to cut it. Well, let's not worry about what he might do. Let's worry about what and I'm using he because 90-something% of the abusers are male. I think that statistic's true somewhere in there. All of my clients are female, by the way. But focus on what the person's already done, the most recent, most violent act, what's going on now, was a weapon used, was there strangulation? Strangulation's huge. Strangulation is very important. Judges are keen to strangulation issues. Be specific with dates and times as much as you can. Write down things in your own words and try not to rely on advocates to write things down for you. It's much better if you do it. They might type it out, but let the words be your words unless you're physically unable to write things down. Somebody might be able to type it or write it out for you, but I would strongly recommend using your own words.
I agree. And another point to make is just that order of protection statute here in Tennessee, for example, it's very narrow. And that's what I have to explain sometimes. It's very narrow. It has certain things listed that if you can prove this by a preponderance of the evidence, then that's a basis for this order of protection. And I think, unfortunately, sometimes folks come in with a lot of things that don't fall under the statute. And yes, that is abusive. That is, like you said, emotional abuse, verbal abuse. It's awful. Definitely grounds for divorce or inappropriate marital conduct. Maybe it's even a factor in a custody petition in the divorce. There's a long list of factors here in Tennessee that are considered when determining custody in a divorce or a custody action. But if it is not under the order of protection statute, then it's not relevant to this particular case. And they cannot grant an order of protection for that. It might have another remedy somewhere else, but it has to fall under the statute. And so it's very important to understand the definitions of abuse in the statute and what is covered and what's not. For example, just something I hear a lot that is awful and abusive but doesn't fall under the statute is sometimes the abuser will say they'll make threats to commit suicide, which is an awful thing. And they'll use that to control a victim. They'll threaten that. But that alone is not going to get you an order of protection. It might be part of the story. It might be part of what happened, but that person threatening self-harm, even though it's a concerning thing, that alone wouldn't get you an order of protection. So just to kind of highlight, that's not abuse technically under the statute of an order of protection. Is it relevant to a custody petition? Absolutely. If somebody's struggling with their mental health like that, serious about their suicidal ideation, then that is super relevant in a custody case. But it's just not really relevant. It's not going to get you an order of protection. Now, it might come up in the hearing, but it's just not going to get you the order of protection. The other thing I think is important to note is I think being an attorney who handles a lot of these is that there are a lot of very common defenses that you just have to kind of think of when you're going into this. I think one of the most common is that you're trying to evict the person, like that this is really just, you're doing this so that you get possession of the marital home and you're trying to evict either a roommate. Obviously that wouldn't fall under the statute. And so you have to be ready for that. You have to be ready for that argument because it's a very common one. The other one being you're trying to get an upper hand in the divorce or custody case. Anytime there's children involved, you can be ready for that argument because that's almost the first thing coming out of their mouth, that the party petitioning just wants full custody. And so you have to be ready for that. If you're asking to keep these kids on the order of protection, child or children, on the order of protection, you really have to know what your basis is for that, because just being afraid of what they might do to the kids, while a completely reasonable fear, and I get it. I'm a parent myself. If somebody was abusive to me, I would absolutely not feel comfortable with exchanging my children with them. But if they are the other parent and you don't have a basis, then that could be used against you to keep the kids on the order of protection, because they're going to say, oh, you just want full custody. So you really have to be ready to explain why you're trying to keep the kids on the order of protection. And saying you're afraid of what they might do is probably not going to get it, and it actually might backfire and affect your credibility to the court. So just, if you are asking for the children to be on there, you have to have a basis of either the children intentionally harmed, or the children witnessed and were present during a traumatic, something that would traumatize a child.
I'd like to thank Rebecca Toca for coming to the studio today to talk domestic violence. She and I will continue our discussion of orders of protection in the next episode, including trying to use orders of protection in cases involving children who've been excessively spanked, applying for an order of protection in stalking, when someone's stalking, harassing you, and then in sexual assault cases. All of that next time in Talking DV. Thank you for listening to Talking DV, a podcast that focuses on providing you with practical information on how to leave an abusive relationship. I'm your host, Dean Hinton, encouraging you to seek legal counsel for your specific case. If you cannot afford an attorney, contact your local legal aid office. Many legal aid offices often offer free legal clinics where you can speak to an attorney face-to-face about your specific legal problem. There's no reason to give up hope.